Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our two-weekly community conference call every other Thursday. Today is February 23rd, 2023, and I'll go over the questions that have been posted to our forums first, which I have marked as frequently asked questions, after which I will address the questions that have been marked as regular questions. And if time remains, I will ask for further questions from people who have not posted. And of course, after I finish answering each question, I will be inviting follow-ups on the topic that I'm discussing. If you have a follow-up question, you can press *5 on your phone at that time, and that raises your hand in my dashboard. So *5. With that, let us get started first on the frequently asked questions. The first one is, how does the H-1B visa cap exemption and the 6-year rule work? Okay, so basically, once you have been counted in the lottery, you don't have to worry about the lottery for 6 years. There's more to it, but let's begin with that basic proposition. So if I got my lottery, H-1B lottery selection done and my H-1B was approved, I do not have to worry for the next 6 years from the date. And this is also kind of complicated. I'll come to it in one moment. Which date does it start from? So first of all, the 6-year rule, USCIS says, requires you to receive at least change of status or a visa stamp. So if you don't receive a change of status like F1 to H1, you are not yet out of trouble. And if you don't get a visa stamp, instead, if you're outside the U.S. and you did not do a change of status, then we consider you to still be subject to the lottery. You're not out of the woods yet. So no visa, no change of status, you are still subject. But here is the problem with that. As a practical matter, just looking at the plain language of the law, that appears to be an incorrect supposition. I do not think that there is any law that says you must have received a change of status or actual visa stamp from a consulate in order to be exempt from the lottery. The plain language of the law just says that you've been selected and you have been approved. So I don't see where the government gets off taking that interpretation. And it has been tested. We have received several approvals where people did not even receive a visa stamp. Okay. So Sanjay, the person who posted this, said, I got an H-1B approval in 2020. Stamping was done in 2022. So you are out of the woods already for sure. Okay. Due to personal reasons, I've decided not to travel. The question is, am I cap exempt and how long does it last? So that brings me to the next question. Remember, we started with the question, when does the 6-year period begin to run? And the last time we actually heard from the USCIS on this issue that I know of was several years ago, where USCIS said we count 6 years from the date till what your initial H-1B was approved. So if your initial H-1B is approved from October 1st, 2023 through September 30th, 2026, 6 year begins from 2026, not from 2023. Okay, so that's an important point to remember. This is the way we believe the USCIS will interpret it. So when you got an approval done, let's say it was approved in 2020, it's probably good till 2023. So your 6-year period should be 2029. Okay. But again, there is more to it. There's something called the remainder option, on which there is really no time ceiling of 6 years even. So, but just to answer your questions for this limited purpose, the 6-year period should be counted from the date your H-1B was approved until. So 20 to 23, 6 years begin from 23. In fact, I'm sorry, I forgot to check if you guys can hear me okay. Let me make sure you can.
The conference is now in conversation mode.
Hey folks, can you all hear me okay?
Yes, we can hear you.
Okay.
Thank you.
Great. Thank you.
Yes, we can do that.
Thank you, sir.
The conference is now in presentation mode.
So does anybody have any follow-up question on the 6-year rule of H1B? Press *5 if you do. Press *5 on your phone. Okay, let's go on to the next frequently asked question. So this is another one that's asked all the time. Will having EAD cards or petition approvals with gaps in the start and end date cause an issue? This is a common problem. Okay, and in most cases it should not cause an issue. Most cases. If there is some extreme problem, that would be obvious. But normally what happens is this gap occurs because of the USCIS's weirdness. They approve most petitions and cases from the date they make the decision, not from the date we filed. And that's where the problem comes in. So let's say my EAD or my H1B or my L1, H4, anything, it's expiring in 1 month. Okay, I filed for an extension and they approved my benefit, whatever I asked for, let's say 3 months later. The approval date would be 3 months later. So my petition or my benefit was expiring in 1 month. They approved it in 3 months. There's a gap of 2 months, right? Is that a problem? I don't see how it can be a problem at all. This is, if anything, when in technology you have latency in communications, in data, etc. It's kind of that latency that is built into the system. I don't think anybody can do anything about it unless government starts approving backdated from the date of filing. But then the problem is you would lose the 1 month that you still have left on your EAD, for example. They could also approve from the date the EAD expires on to the maximum period allowed. But until all that happens, we are going to have to deal with these gaps, and they should not be a problem. So let's look at the question that is asked. There's actually 2 people. I don't know if it is the same. I actually merged 2 posts. One was from Janaka Agarwal and one is this one. I might have messed that up. Let's deal with both questions. So first part of the question is, which was the original poster, I recently renewed my green card EAD. The first EAD expired in April 2019. I had filed for renewal before the expiration. The USCIS provided a 540-day auto extension. The original EAD is valid till October 2023. The new card is valid from Jan 2023. So there is a gap from April 2019 to Jan 2023. That doesn't make any sense. Oh, because of the 540-day auto extension. So basically, if you are covered by that extension, just because there is a gap on paper, there is no problem. I don't know your case, but if you are covered by that 540-day allowance and there is a 300-day gap or 400-day gap, I don't see it as a problem. If it is more than 540 days, then I would be worried because that doesn't make any sense, right? So your case looks a little weird because you filed in 2019. But when did you get the approval? The new card is valid from Jan 2023. Is that more than 540 days? I wonder if you're on the phone. If you're on the phone, please press *5. I want to talk to you. Are you on the phone? Press *5. Because I'm a little confused with your facts. So, okay, take this away from this conversation that gaps are normal. If the gap is abnormal, let's have a discussion with your lawyers. Make sure there is no problem. But I wouldn't worry about it. Because this is, like I said, almost like latency in data processing. This is built into the system. Okay. Second part was from Janak Agarwal. I think I might have messed this up. This might belong with the first question. It says, I had 797B with Infosys. I had changed job to Cognizant. I had 797A with Cognizant. So B is when you don't get change of status. A is when you receive proper status. Okay. I had to return to India in September. I'm in India since then. I think this question belonged with the first one. I'll move it later after we finish this call. Recently applied for H-1B again, cap exempt category with new. My petition is approved and valid from 23 to 26. Now my questions are, once I come to the USA, will I be able to get 3-year extension in Jan 2026? After coming to the USA, how soon can I file for green card? Let's take the easy question first. How soon can I file for green card? You can file for green card even before you come to the US. You can apply for it now. You can apply for it once you come, the next day, the same day. There's really no bar. Okay. Now, will you get 3-year extension? For that, we'll have to look at your case. You got a 797B, which means you never got change of status. Then you got 797 from 2011 to 20. So you've used 2 years of your H-1B, from what I can see. Jan 2011 to August 2023, a little bit over 2 years. So whatever you did not use, you will get back subtracted from the 6 years, but not more than that, because you have chosen the option of being exempted from the lottery. This is something called a remainder option. So remainder option means if I've used 2 years of my H-1B and I went outside the United States for 1 year, I have an option. Either I can reset the clock of my H-1B to 6 years again, but then I'll be subject to the lottery, or I can just take the remainder 4 years, because I've used 2 years already. In that case, I'm not subject to the lottery. Since you came back outside the lottery, it appears that you have taken the remainder option. That means whatever time remains, which is a little bit over 2 years, have been already utilized. So you should have a total of what, my math is bad, guys, 3.5 years, right? So that's what you'll be looking at. Yeah, this should be moved up to the first frequently asked question. Any follow-ups on this, folks, what I've just discussed? Press *5 if you have any follow-up questions. Okay, let's move on to the next frequently asked question, if there is one. It doesn't look like I've marked anything else as a frequently asked question. Oh, there is one. Oh, this one is important. H-1B layoff options. Going to home country and applying for jobs, going through the lottery again, documents required to apply for a new visa to explain missing pay stubs, and the contents of the documentation for termination contract sent by the company to the USCIS. Okay, so that's a whole lot of things to talk about. So first of all, if I get laid off, I'm not able to apply for a transfer, let's say within 60 days. And I was not able to convert to curricular practical training based student visa status or H4 or some other status. Let's say I have to go to my home country, and let's say it's India. Can I apply for jobs while I'm in India? Sure, absolutely. Do I have to go through the lottery again? Well, if you actually got your H-1B approval, I don't see why you should have to go through the lottery again, right? So no, you should not have to. Documents required to apply for a new visa and explain missing pay stubs. There's no need for a continuity of pay stubs. That's a huge misunderstanding people have. So let's say I got my H-1B approval, but I only worked for 1 week. And then after that, or even for 1 day, and then after that, I have no pay stubs. For my next H-1B, I don't need those pay stubs because I never worked. Where am I going to generate the pay stubs from? So don't worry about that part so much. Now let me see what your questions are. I'm on H-1B, got laid off. If I don't find a job in 60 days, can I go back to my home country and work? Sure. Should I have to go through the lottery again? No. What are my options? I talked about H4 as an example. Curricular practical training on student visa is an option. What additional documents do I need? You actually just need a copy of your H-1B approval. What does the company that let me go send to the USCIS as documentation for termination of contract? Okay, so in order to conclude an H-1B, if an employer wants to conclude an H-1B, they have to do 3 things. They have to inform the employee that their job is terminated. Number 2, they have to offer the employee one-way ticket back to their home country. And number 3, they have to put down in writing and request that the H-1B be revoked, because they have to write to the USCIS. All 3 things have to be done. If they have neglected to do any one of them, they are technically liable for salary. So you could actually make a complaint to the Wage and Hour Division of the U.S. Department of Labor. For example, if the employer did not offer you a ticket back to your home country, you could say, okay, fine. That was 8 months ago. You have not, offered me a ticket. Technically, I'm not fired. Pay me my 8 months salary. And at that point, the Wage and Hour Division, at no cost to you, steps in, investigates, and they get your salary from the employer. Okay. Just bear in mind one thing. There's a deadline. They can only look back 1 year to get your salary. So if you wait 3 years and then file a complaint, you won't get your salary. They can't get it for you. Okay. *5. If you have a follow-up question on this, press *5. So, under H-1B, employees actually have greater rights than the employers do as far as the balance of power is concerned. Because the Department of Labor is pretty serious about enforcing the law. And they can really, I've seen companies close down because they had rampant practices of H-1B abuse. Not only that, they can go to prison. Okay, let's start now with the regular questions. Oh, by the way, *5, if you have any follow-up question on what I just talked about, press *5. All right, let's go with the, there is one. Area code 302, I wonder where that is from. From Delaware, okay. Delaware, go ahead, I can hear you.
Hi, Rajiv sir. This is Sharif here. So I do have a follow-up question with the H-1B revocation when you said.
Mm-hmm.
So what if the employer reaches out to USCIS and lets them know that, we've laid off the employee, but within the 60 days, if you're able to find another job, does that count against the employee? Like,
okay, let me try to get
like
this.
Does that impact the case?
Okay, let me try to understand your concern. Okay, I'm not sure I do understand it. So there are 2 different sets of requirements. One is protecting your status. The other one is protecting your salary. Okay. The regulation that is protecting your status says, okay, if you get laid off within 60 days, if your transfer is received by the USCIS, you can actually start working when they receive the paperwork, and we'll consider you to be still in status. That's one regulation, right? The other regulation protects your salary. So let's say they laid me off, then for 55 days, they didn't tell me that they will offer me one-way ticket back to my home country. And on the 56th day, they offer me a one-way ticket. Actually, I'm entitled to 55 days of salary, even though I have a transfer pending. Does that make sense?
Okay. Yeah, that makes sense.
Okay. Yeah, so these are 2 separate issues. Try not to conflate them. It's easy to do that. But really, these are 2 different things altogether.
Okay.
And the best thing is they don't charge you anything. It's not like you have to pay. Never hire a private lawyer for something like that. You can go online, download the form, just Google Wage and Hour Division LCA complaint. LCA is Labor Condition Application. So you can, or foreign worker complaint, you should be able to get that document. I think it's called WH4, Wage and Hour Division 4, WH4. File that, they'll take care of it for you. Okay?
Okay. Thank you.
You're welcome. Good luck. All right. Now let's get back to our regular questions. Then we have a question about, and this is from Jay-Z. It's question number 3. PERM labor certification transfer. You can't do labor cert transfers anymore. That was before 2005. So that's almost 20 years old law. Filing PERM using the experience gained with the previous employer. Sure, you can do that. Filing employment and marriage-based green card concurrently. Yes, you can. No problem at all. And does the US monitor temporary visa and green card holders? That I don't understand. So let's go to your questions. I'm working at company A. Company A has acquired company B. Me and my job got transferred to company B. Can I continue my PERM that is filed by company A? Sure, if the new company is a successor in interest. You can actually Google this. Successor in interest, PERM, or successor in interest I-140. It's in the USCIS policy documents. So if the new company takes over the old company through whom you were doing this process, and they take over your job, etc., and the job remains the same, you might be able to continue your PERM as well as your I-140. And if you're at the I-485 stage, you will have to file an I-140 amendment. But if your I-485 has been pending 180 days, you can just do an AC-21 supplement J. So there are various scenarios. But the short answer is, if the takeover was in a way that is considered to be a successorship in interest by the USCIS, you can continue your green card without any interruption. Okay? And then we come to the experience and masters I gained during working at company A. Can I use that in PERM at company B? If you're going to start a new application, now this is where things get kind of interesting. So far, US Department of Labor, their regulations very clearly say if we consider separate tax IDs to be separate employers. So let's say you worked at IBM Arizona and you got experience there, and then you, and it's a different corporation, different corporate entity. Let's make it simpler. Let's say you worked at IBM Poland, okay, or IBM UK for 3 years. And then you came to IBM USA, and these are, let's say, two different companies with different tax ID numbers. You can use that experience because these are two separate entities, okay? But if they are a successor in interest, can you then use that experience? That I don't know, okay? But if you're starting a totally new labor cert under company B, I would argue they are two different companies, but I would have to look at more information. So it may be possible or it may not be possible, depends upon the nature of the case. You may be able to use the masters, you may not be able to use the masters. But here is another thought, okay? Let's say I join with a company as a software developer. This is important for all of you guys. Let's say I join a company as a software developer. I work for 3 years or 2 years. 2 years later, I want to apply for a green card. Can I use that 2 years experience? The answer is yes, if the job being considered for PERM is more than 50% different from software developer's job. For example, the next job or the PERM job is team leader, okay, or systems manager. How do you know when two jobs are more than 50% different? Well, it's the nature of the duties. When I'm a techie, I'm sitting there, I'm doing systems analysis, I'm doing coding, I'm doing quality assurance, I'm doing typically what a software developer does. I'm doing implementation, I'm training people, and then I am supporting what I have installed. But when I am team lead, I don't do all that work, I guide all that work. When I'm manager, I don't do all that work. I may occasionally do it, and that's allowed because the jobs don't have to be 100% different. They just have to be more than 50% different. So that's a possibility. I hope that makes sense to everyone, okay? Can we file both employment and marriage-based green card simultaneously? Sure. Which one will be valid? Whichever one you get first. Are visa and green card holders monitored by the US? Well, you have to file a change of address forms, but monitoring, we have constitutional rights. To some point, they can monitor people, but do they listen in on your conversations? Let's say you're talking to your dad in New Delhi. Are they listening in? I don't think so. There is a whole lot of issues with something like that. They have a warrant from a court. Yeah, maybe they can. Okay. *5. If you have a follow-up question on this, press *5. Next question. Does having a US sponsor increase your chances for an F1 visa? I don't think so. I do not believe so. *5 if you have a follow-up question on this. Okay. How does the L1B 60-day grace period work? Just like an H1B 60-day grace period, no difference. TN, L1, O1, H1, I think P1 also, all of them work the same way. Will having a Canada visitor visa help? I don't know. I'm currently on L1B, got affected by a layoff. Trying to check if it's possible to get a new job in US or Canada. First of all, I don't know anything about Canadian laws. I can only comment about US laws. My last day will be March 20th. In the search and found an option for applying for 2023 H1B cap. Yeah, you can do that. Since H1B will be approved only in October. So there's a gap. You're worried about the gap. Let's see. So you are good till March. Then you have a 60-day grace period. Within the 60-day grace period, you applied for an H1B. This is an interesting problem because you are applying within the time permitted. And from what I remember, I'm taking a parallel from student visas. So if you are on a student visa and it's a very good example of your situation. So follow closely. When you are on a student visa, let's say your OPT is expiring, then you have 60 days of grace period. Okay. So there are several possibilities. April 1st is the date we start the filing for the next fiscal year of H1B, right? So if your OPT is expiring after April 1st, and this is a rough, very rough outline because there never used to be second and third rounds of lotteries. If there's only one round of lottery and your OPT plus 60 days, no, let me take from the easier example. Your OPT is expiring after April 1st. You get gap extension. So that means you can continue working. If your OPT is expiring before April 1st, but you still have 60-day grace period, you can stay in the United States waiting for the H1B approval, but you cannot work till October 1st. Okay. So if you are coming again to revise this, if your OPT is expiring on or after April 1st, you get gap extension, you can continue working till October 1st. Okay. If your OPT is expiring, but you're within 60 days of April 1st, you can stay in the United States. That is kind of what I think, somebody should look into it. I haven't thought this through, but I think this is a possibility. What if I apply for an L1, from L1 to H1B transfer, within the 60-day grace period? Can I stay in the United States? I don't know. I think it's an interesting question. But what is the worst case scenario? Keeping in mind unlawful presence issues, if unlawful presence is not a problem, worst case scenario is you have to go get an H1B visa stamp, but you cannot start working before October 1st. Kind of complicated, but this is the way it would work. So once again, I can apply for the cap. I have a problem because H1B visa will be approved only in October. You could also apply for a tourist status, right? B1, B2 status. Now, that I think would be a good way. It's not an easy solution because there are other problems, but it prevents you from accruing any unlawful presence. And on top of that, it is possible that if by the time they make a decision on your H1B, your tourist status is approved, they will then give you an H1B within the United States. So applying for a tourist status is a good middle ground for you. Okay. *5. By the way, having a Canadian visitor visa does not help. Press *5 if you have a follow-up question. Okay. This is from area code 571. which is my neighborhood, Virginia. Okay, Virginia, go ahead. I can hear you. Virginia.
Hey, Mr. Rajiv.
Yeah.
This is Anuj.
Hi, Anuj.
I am working with you and Anna already on
Oh.
getting the retainers in.
Why are you calling here?
I just spoke to.
Just call Anna. She'll set up a call for us.
No, I'm a big fan of yours, anyways, from UD,
Oh,
the Instagram mentor. So I still attend your community calls, and my father still does.
Oh, wow.
My question here is that we're working with you. My father just went back to India. Say if he comes back and if his lottery is picked and we go ahead with the petition, he already has a tourist visa status. So how would he be able to stay here till October 1st and not leave the country?
So Anuj, this was a question about your dad. He had an H1. He had an L1.
No, he didn't have an L1. We're working to get H1. He doesn't have an L1 or
Okay,
H1.
so
He
let's.
just has a tourist status
This is a
right
totally
now.
different issue. Okay, all right. So
Okay.
here's your question. Your question is, your dad is in India. Let's say that lawyers apply for his lottery, right? And he gets selected. That's what you're saying? Okay. Now, there are two possibilities.
Once it gets selected.
Right. So then there are two possibilities. Once he gets selected, he's either in the US or outside the US. Okay. I would, even if he were in the US, I would probably select consular processing rather than change of status, because technically he can change status. Okay. But if somebody enters the United States on a tourist status and they want to convert to something like an H-1B, even though the rule has been taken off the books, there used to be a 30, 60, 90-day rule that became a 90-day rule, which said, don't try to change status within 30 days. Don't try to change status within 60 days. All those rules were thrown out by the Biden administration, but the underlying principle still remains. If somebody enters using a tourist status, but they have a preconceived intention to convert to H-1B, as is evident from the fact that they applied for lottery, would that be considered a misuse and a misrepresentation regarding the tourist visa? I would fear that. So what would I do? I would apply for their H-1B with consular notification. If the H-1B gets approved, I'll send my client to Canada, Mexico, Costa Rica, Jamaica, New Virgin Islands, I believe, Bahamas, anywhere close by where they can get an H-1B visa stamp and come back. Okay, that would be the smarter thing to do, in my opinion. Make sense?
So basically, you'll just send them off to a vacation.
Yeah, and I'll tell them that you have to bring your son along because somebody has to be there for you. So yeah, no problem. We got you covered.
No, thank you.
Okay. Good luck.
Thank you.
All right. Take care. Bye-bye.
Thank you.
So this is from, I think it's India. Hi, I can hear you. Go ahead, please. I think you're from India.
Hi, Rajiv. This is Sanjay, the one who posted the first question.
Okay. Go ahead, Sanjay.
Regarding the gap exception. Okay. So I have a question on it.
Sanjay, hold on.
As per my understanding from the
Sanjay, 1 second. Which question are we talking about?
Yeah. Sure.
Which question?
The one which is regarding with the gap exception, 6 years.
There were a couple of them.
The first question.
Oh, the very first question. Okay. All right. So what were we talking about? Go ahead.
Yeah. So as per my understanding from the conversation, you said like 6 years period starts from the end of my
Yes, sir.
campaign.
Yes, sir.
Right?
Yes, sir. It does.
Okay. So, anything after that, I have to go through the...
Actually, it's not that simple. But let's take your example. You got your H-1B approval in 2020. Okay. I'm assuming it was approved till 2023, right?
September, yeah, that's right.
Now, here is the interesting problem. If you had come to the United States and worked here for, let's say, 1 year and then gone back again, you would, after 1 year, have an option to either capture back the entire 6 years but go through the lottery again, or take the remainder of the H-1B, which is 5 years. If you took the remainder option, there is actually no limit to how long you can wait. You could do it in 20 years. At least that's the way the law is shaping up so far. Okay. But since you are not taking the remainder option, okay, then because of that, we are kind of stuck in a situation where you have fewer rights than you would have had if you had come and worked here 6 months and then gone back, or 5 months and gone back. Okay. So in your case, one thing is clear, that you should be entitled to 6 years. It is not written down anywhere when that 6 years period begins. USCIS has said in various conversations, in conferences, etc., we will consider it from the date your H-1B was approved to. So if you were approved till 2023, you have till 2029. Got it?
Okay.
That's the way we see it.
Okay. Got it.
All right. Very good.
Got it.
All set?
So after 29, so after 2029, I should go through the fresh.
I would still argue
case
for
if I
you.
want to come.
I would say, look, I have remainder of 6 years. I'll take entire 6 years. I don't want to go through the lottery again. So I would say I'm taking my remainder option. I don't think it quite works like that, but you never know. Doesn't hurt to argue, right?
Okay.
All right.
Okay. Thank you. Thanks.
You're welcome. Good luck, sir. Okay, now back to our, I think I should lock the conference just to make sure I cover everybody here. 1 second, guys. Conference locked.
The conference is now locked.
Yeah, so anybody who's here, I'll try to answer all their questions. Now let's go to, we did this one, we did this one, L1B grace period, we did this one. Okay, so this is something I actually did today. One of our clients was asking me the same question. Can I visit my spouse on a B1, B2 with an approved I-130 while waiting for my visa process to be completed? And the answer is, yeah, I think so. Okay, especially if your spouse is a US citizen, although even immigrants should have the same benefit. So what I have noticed is that almost everybody in that situation that I spoke with over the last 1 year, over the Biden time, they all got their tourist status. Now that may be just coincidental, but it appears that the government is not raising a big bellyache about, oh, you can't go on a tourist visa when you have a green card pending. It looks like they're letting people come in, especially when the people appear to be the reliable types. I mean, why would I want to break the law if I'm going to get my green card in 6 months anyway, right? So it's worth trying. As long as you don't try to conceal the fact that you have a green card going, I see no harm in trying. *5. If you have a follow-up question, press *5. Okay, let's go on. Nirav says, oh, there is a question from area code 678. Where is that? Georgia. Okay. Georgia, go ahead. I can hear you.
Yes, Rajiv. This is the question regarding visiting on B1, B2. So this is actually regarding my son-in-law. So he has visited twice while the I-130 was pending.
Yeah.
And now it is approved. So you don't see any problem. No. And if they deny the entry, would it have any impact on its application?
Okay. So, Iftikharji, where is your son-in-law coming from? Which country?
Germany.
Germany. I would recommend that he take his US flight from from Dublin, Ireland. Okay.
Dublin, okay.
Yeah. Why? Because they'll do his immigration processing right there. Okay.
Okay.
That way he knows before he flies whether he can enter USA or not.
Okay.
Okay. Because they do immigration processing in Dublin, so people coming from Europe have an edge that they can just, they know right there whether they are going to be able to come in or not.
Okay.
Okay. That's
and
number
if they
one.
deny, is there any
No, I'm coming to that.
problem?
No, I'm coming to that. Number one.
Okay.
Number two,
Okay.
there are two ways you can be rejected by the Customs and Border Protection, whether they do it in Abu Dhabi or they do it in Dublin or they do it at a US airport. There's two ways they can reject you. Okay. One way is the nasty way. The nasty way is they'll say you are formally excluded. Now you cannot come back for 5 years. Okay.
Oh, okay.
The other way is they'll say, you know what, we're not going to let you enter, so why don't you withdraw your application? And you can say, okay, I withdraw. That means you take your next flight back. Now, is this within their discussion? As long as you have not lied about anything, I don't think they would ever put you under the 5-year bar. They ask a question, you answer it truthfully, it's all straight up and up, one way or the other, it's decided. So I'm not worried about people who are being truthful being hit with the 5-year bar. Okay? So I don't see any harm in that. Anything else?
Okay. Thank you.
Oh, you're welcome.
Thank you very much.
You're welcome, sir. Bye-bye.
Bye.
Yeah, Anuj, what happened? You had something else?
Sir, Abu Dhabi would work as well, correct?
Yeah.
For this purpose?
Uh-huh. Yeah, it will.
Okay.
Yeah.
And it's little sidetrack, but it's related to the B1, B2 re-entry.
Uh-huh.
So they were my parents visited. They were here for a year. We applied for the extension. I still have not received an answer back from USCIS.
Okay.
But my parents have now exited the country, now are in India.
There's a problem. Hang on. They're going to have a problem. So if you Google my name, Rajiv S. Khanna, Economic Times,
Okay.
you will come to an article that I've written, and that reminds me, I haven't written for them for a while. There's an article I wrote about how stupid the government is being in interpreting something called Section 222G of the Immigration and Nationality Act. 222G says, if you overstay your I-94 for even 1 day, we consider your visa to be automatically cancelled. And this is true even if your tourist status request was pending. Okay. If we grant it, you're okay. But if your request is denied or you leave while the request is pending, we will consider your visa to be revoked. I actually showed standard operating procedures of the State Department, which say if you leave before a decision is made, 222G should not apply to you. Okay. So the bottom line is, if your parents left while their extension request was pending, and on the date they left, their original B2 stay had expired, I would worry that some idiot might think them to be subject to 222G and tell them, oh, no, sorry, you have to go back, apply for a visa and come back again.
Okay.
Okay. So what should they do? They should test this out at Abu Dhabi. Makes sense. Because if they are declined, well, they can go shopping and go back.
Plan.
Yeah.
And no, I had proper validation. I had a proper letter for the extension and everything.
Was it granted? Was it granted?
No, it wasn't. No, it's not granted. That was the whole scene.
It's still pending, right? That's what you said.
Yeah.
So if it is granted, they are good as gold. If it is not granted, it's an idiotic interpretation by the CBP, which actually runs against the interpretation of the State Department. I don't think 222G applies. I don't think their visas are cancelled because they left before a decision was announced. Okay.
Makes sense.
So that's what I would argue. But, you and I can be scholars. It doesn't really matter. Ultimately, it is the officer at the airport who decides. Okay.
Correct. I agree.
So be careful with that. Good luck.
Thank you.
You're welcome.
Will do. Thank you.
Okay, area code 419. Oh, there's a bunch of raised hands. Guys, if you are not asking, I hope you're not asking new questions. Let's just go to raised hands one by one. We are done with, we just finished Anuj, so that's done. Next is 419. I don't know where it's from. Area code 419 is Ohio. Okay. Ohio, I can hear you. Please go ahead. Ohio.
Hi. So I applied for my parents' B1/B2 visa, and they got the visa, but they couldn't come visit me during the 5 years they had because they had a lot of stuff going on. So now I'm applying for the renewal. Would that be any problem because they never really utilized the first visa?
No, it's kind of weird. Okay. To me, somebody's good intentions are made quite clear when they don't even use a benefit they have. Okay. But some officers, I have heard, not very often, some officers say, why are you getting visas if you're not going? My answer to that would be, I am paying you, right? You should be happy I'm paying you for nothing. So what is the problem? Personally, I don't think it's going to be an issue.
Okay. Great.
Okay.
And plus, I don't think they're going to have an interview now. They actually,
No.
because I already applied, so they qualified for the waiver.
Yeah, they qualify for the
hope they
interview.
just understand because they're not really going to be conversing, right?
Yeah, I don't see why it
that
would
was
be a
my
problem.
question.
No, they are not going to deny just because they didn't use the visa. I wouldn't worry about it.
Okay.
All right. Good luck. Okay, so the next one is New Jersey. Okay. New Jersey, go ahead. I can hear you.
Hi, Raju. Hi, Rajuji. I heard the example that you just said for Blvd extension and still pending. So I raised my hand just to tell an example of a grandmother.
Yeah.
She was here during COVID for 6 months on B1, B2, and then we applied for an extension. Her extension is still pending.
Right.
She left
Right.
after her initial 6 months,
Right.
but when the extension is pending.
Right.
And then she came back after 6 months,
Okay.
back to the U.S.
Okay.
I think that's one example I wanted to.
They didn't create any problem, the Customs and Border Protection?
No.
Well, that's good for you. But I'll tell you something. In between, actually, the consulates had started sending emails to people like this. They said, well, your visa is now canceled. And that's when I wrote that article. Okay. Now, good to know that CBP has at least not taken that position in your grandmother's case, but I would still worry because I haven't seen anything in writing from them. So therefore, I always prepared for the worst. And I say, let's get you processed through someplace close to home so you don't have to travel 20 hours to be turned back again. That's not pleasant.
No.
Right. So, but thank you for sharing. I appreciate that. Good to know.
Sure. And then I have one more question relating to B1, B2 and green card.
Sure.
So she is coming back in March, and then we are trying to file her green card as family-based green card. And how long should we wait after she comes here?
Yeah. Look, first of all, don't tell her you are planning to apply for a green card because her intention is important. Your intention is not important. Okay. But she should not enter the United States on a tourist status intending to file an adjustment of status. Okay. How long? Wait as long as you can. 4 5 months. Don't make her bring any documents because couple of reasons. One, that means you informed her and she knows what she's doing. And two, she can be, if her luggage, etc. is looked at, they can find those documents and create a problem. Okay. So I did not used to be paranoid about this, but during the Trump administration, we did a series of cases where parents were being deported because they came in on tourist visa, which is absolute nonsense. Okay. But during the Biden administration, we haven't seen that. The rule was always that immediate relatives of US citizens were not subject to this nonsense. But then during the Trump administration, weird things happened. And we actually had a case in New York which ended up going to court. I don't know, I don't remember exactly what happened. Was it settled, or it did get resolved, but it was quite problematic. So don't tell her what you are planning. Don't make her bring any documents. Okay?
Okay. And once she's here, how long do you think is an ideal time to wait for her green card?
More than
filing?
90 days, as long as you can wait. 4 or 5 months maybe. Because once you apply for her I-130 485, she's good to stay.
Okay.
Okay.
And then let's say we file her green card after 4 months. Should we file her B1 B2 extension at the end of 5 months?
I usually don't, because it's a waste of money. Once again, I'm assuming you're filing I-130 and 485 both. It's mom or dad of a U.S. citizen. I would not do an extension for those folks.
Right.
No need to do an extension.
Okay. Thank you.
You're welcome. Good luck.
Thank you very much.
You're welcome. Okay, so Nirav Bhatt said, current economic uncertainties, can I use my EB2 EAD or F3 family petition EAD after my H1B expires? And on what EAD can my spouse travel? The answer is yes, you can use an EAD. So I have filed 2 I-485. One is from the employer, another is from my family, father. Okay. I've got 2 EADs. They should not have issued you 2 EADs. They should have issued only one. But I don't know. I think you can use either one of them. I don't see any problem with that. Okay. I cannot see a single thing which would be problematic if you chose one over the other. My current H1B expires on Feb 11. My company didn't file an extension. Got an offer from another employer for a managerial position. Well, congratulations. Should I use my EB2 EAD, or I don't think it matters. Use either one. Will it void the other EAD? I don't think so. If my wife wants to visit India for a medical emergency, which EAD? She'll be using an advanced parole. And once again, either advanced parole should be okay. I can't see why that would be a problem. If you want to be even more sure of this kind of unprecedented situation, you can make a phone call to the USCIS customer service. Your questions will be most likely escalated to a service officer, to an adjudications officer. Make a note of the date, the time, and the name of the officer you speak with. Either they'll give you their first name or they will give you their badge number. So either one works. Okay. *5 if you have a follow-up question. *5. Okay. Oh, there is a question, and this is from a blocked number, so I don't know where they're calling from. Go ahead. I can hear you. Go ahead, please. Hello. Your number shows as blocked, so I don't know where you're calling from. Hello. Okay, so I don't know what happened. Can a student on F1 STEM OPT open an LLC and employ himself, then file for H1B through that LLC? Well, if there is an employer-employee relationship, okay, so that somebody can fire you. For example, let's say you hold 20% share and you have other people holding 80%, and you have a proper supervisor who can train you and certify that you're being trained, etc. Sure, why not? But if you are yourself the king and you are yourself the farmer, that becomes impossible. That's not going to be allowed. Okay. Can you do H1B for companies that you own? Sure. If there's an employer-employee relationship, easiest case is you are a minority stockholder. But even if you're a majority stockholder, there are people like a board of directors that can fire you. There is a chance you'll be able to get an H1B. Word of caution, USCIS will probably accept that, but if you go for a visa stamping, you're going to have a problem. Consulates take a different opinion. They consider this kind of an arrangement to be unacceptable. I think it's open to legal challenge. but consulates are difficult to challenge anyway. *5 if you have a follow-up question. *5. Could you please tell me if I forgot to answer this question. Can I start a vending machine business? No, I don't think so. Is this an active or passive income? I think it's active enough for it to be a problem. No, I don't think you can do that. I already covered the employer-employee issue, so okay. Next question is Liana. L2 status ends. Change of status to F or E2 visa, and can the company apply for I-485? Can spouse's L1 visa extension be an advantage? Okay, let's see. I'm on L2. My company is applying for my green card. L2 status ends in 2024. As my company might not manage to apply for I-485 before 2024, I'm considering changing from F to E2. Yeah, sure, E2 is a great status. If my L2 status ends and my change of status to E2 is in process, can my company apply for I-485? Very good question. And the answer is, if your F status, including the 60-day grace period, has not expired for more than 180 days, which is called Section 245K as in kite of Immigration and Nationality Act. So you have a 180-day grace period within which the 485 can be applied. Can I withdraw my F2 E2 change of status while the 485 is in process? Sure. Or I will be considered an illegal. No, you should be able to withdraw once the 485 is filed, because if that 180-day period, grace period, protects you. If my husband's L1 visa will be extended, am I in a safe position? Sure. You got your L2. You got to get your L2 extension also done. You should be able to apply for I-485 within the 180-day grace period, even if your L2 expires. That's the beauty of Section 245K. It really offers good protection. *5. If you have a follow-up question on this, press *5. All right. One question was deleted. Shin Chen. Green card filing process. Oh, there is a follow-up question from area code 419, which is Ohio. Yeah, Ohio, go ahead, please. Ohio.
Yeah, so around the same thing, the I-485, can you also apply that within 180 days of your F1 status expiring?
Absolutely. So the law is people who are applying for employment-based 485 and also their derivatives can be out of status for up to 180 days. No problem at all. Okay?
Okay, thank you.
Good luck. Okay, so this question we already covered. Shin-chan says, is it possible that I can initiate green card filing on day one? Absolutely. Is it possible that I proceed with you for green card filing? You can accept a bank check from my account? No, sir. I can't do that. We have a policy that we do not accept funds that are statutorily to be paid by the employer from the employee. So we will not accept that, no. The reason behind that is this is the law. Okay, the PERM process should be 100% paid by the employer. This is in the law. The I-140 we think should also be paid by the employer, especially of H-1B employees. So I-140 is questionable, but for H-1B I think it should be paid by the employer. So the first two petitions, I-140 and PERM, we don't take checks from the employees, because then we would be helping you break the law. Okay, we won't do that. And that's the reason. Is it possible to pay the fees as per needed for green card process? I'm not sure I understand that question. Shinchan, if you're here, press *5. I'm not sure I understand your last question. Okay, you're not here. Let's go on to the next question. We covered that. Okay, all our questions are covered. Press *5 if you have any question. Press *5 if you have any question. Okay, we have only one question today. Or 2 questions. Okay, 3 questions. And let's start with people who, in the order that they logged into the call. Anuj is the first one who logged in. Anuj, go ahead, please. Anuj?
Hey, sorry, I don't mean to take up a
That's
lot
okay.
of time
Go ahead.
of others.
Mm-hmm.
But basically my question was, I mean, it's been over your forums a lot of times. Can multiple employers file if they're completely unrelated, they don't have any relation, no interlocking directors
Yes.
or partners?
Yes, they can file. Absolutely.
What if one employer is a client of the other employer?
That can be a problem because that smells of collusion. That seems like you're trying to increase the chances of the employee. So I would probably avoid that.
Okay.
Okay. I would.
The scenario here is one of the employer that's trying to file is filing from another business for my dad, but I'm employed for one of his business.
Okay. So if a son is either a stockholder or an officer in a company, I would consider that to be related companies.
No, I'm just an employee.
Okay. If you're just an employee, so let's say there is a company X and there's a company Y. Okay. And you are just an employee of company Y. Remember, it's not the relationship between you and your dad that counts. It's the relationship between the companies that counts. Okay. So people of company X and company Y should not be related, even with the business interests. So if one is the client of another, I think that's a problem.
It has the same owner. So company X.
Same owner, to absolutely not.
Absolutely
not. No. Same owner is absolutely forbidden.
So if I'm working for one company and the other company is trying to employ my dad, and if it has the same owner, then it's a no-go.
No, that's not a problem. If the company that you are working for and another company, both being owned by the same group of people, are both applying, that's not allowed.
No. Both are not applying.
So the fact that you are employed by a related company has no bearing on one company applying for him. That's not a problem.
Yeah. The reason we're not doing it from the two companies because there's no position opening where I work.
Yeah. So that issue is.
The other one is a car dealership.
Yeah.
And the person basically cannot focus on his business, is making loss.
Okay.
He's not able to find the right person to run his operations, and he wants a trustworthy person.
Look, I'll tell you first problem I have is you won't get an H-1B for that position because that doesn't require a degree. That's a different issue. But business development or business management operations, very difficult to get an H-1B. Very difficult to convince the government that this job requires a specific degree. Now, I can understand if you are running Microsoft, you need at least an MBA level or an engineering level person. Okay. But if you are running a car dealership, I don't think you need a degree for that. However, if you're running 11 car dealerships, maybe. Okay. So you have another problem there.
Got it.
All right. Good luck.
Okay. Thanks.
You're welcome. Okay. So then we have, again, Ohio. Ohio, go ahead. You had a follow-up question? Go ahead, please. This is Toledo, Ohio. I also have Dublin, Ohio coming up next. So Toledo, go ahead, please.
Yeah. So one of the things I have read is if you're applying for I-485, it might be good to have a status, a non-immigrant status. So in case your I-485 is denied, you have something to fall back onto.
Okay.
Considering that,
Yeah.
if that is true,
Mm-hmm.
I have a follow-up on that. If that is true,
Mm-hmm.
I am currently on F1.
Mm-hmm.
On my third year of OPT, didn't get picked for H1B first 2 years. We're trying this year as well.
Mm-hmm.
But I'm also in the PERM process.
Mm-hmm.
And I'm worried that by the time they apply for I-485,
Mm-hmm.
it might take a lot of time for me to get that EAD C09.
Right.
So maybe I should start a day one CPT before applying for I-485.
Yeah, I don't see any problem with that. But let me clarify a couple of things for you. I have a feeling you may not have considered that. First of all, let us say that your student status is over and 60-day grace period is over, but you're still here. You still have 180 days to file 485. Once the 485 is filed, you don't have an EAD. That is not a problem. Okay. You can't start working until you get the EAD, but not having an EAD doesn't put you out of status. Your legality is governed by the 485 filed within 180 days. It is not governed by the possession of an EAD. Okay, so don't think there's a little confusion there. These are two separate things. But should you do an F1 CPT? Sure, why not? I don't see any problem with that.
Yeah, you're right. That part was clear in my head. Maybe I didn't
okay.
phrase it right.
Okay.
The legality thing. It's just the reason why I still want to be able to work.
Yeah,
is
of course.
Like,
You like to eat.
or like, have F1 status in case my I-485 is denied.
Well,
so
you know,
something to fall back onto.
If you look at our frequently asked questions, everybody who's on L1, H1, I always tell them, O1, keep your visa status active. Do not depend only upon 485. But there are situations where we don't have a choice. Okay. In those, for example, if you're on a tourist status, there is no need to extend that. They're not going to give it to you anyway when you have a 485 pending. Okay. So where you have a choice, sure, go ahead. I think it's a very good idea.
So in this process, at what step I can still, I guess, go back to day one CPT? Is it right after I-140 but before I-485, or I can still do it after I-485?
I think you can do it even after the I-485, and you can double check with your DSO. Because when you go from F1 to F1, they don't have to file any paperwork with the USCIS. Okay. So therefore, this is all done internally through the service system. I don't think you should have a problem, but you can double check with the DSO. Okay.
Yeah, I'll double check. I'm not on H1 though. If I was, it would have been a lot easier.
Oh, that's a lot easier.
I do have one more question. I think you kind of answered it.
Sure, go ahead.
But just to be clear, if I may.
Of course.
So in this whole process, I can never transfer PERM or I-140 to any other employer. Like if I change my employer after I-140, I still have to redo the whole thing.
That is correct. But if you change after 180 days of I-485, then you are safe.
Oh, then I'm fine. Like then I don't have to redo I-140 or.
So if your I-140 is approved,
just the I-440.
Yeah, if your I-140 is approved and your 485 has been pending 180 days, you can change jobs by filing not required but recommended supplement J. No problem. You don't have to redo the green card. Okay.
Okay. Not that I'm intending. I just wanted to
that's
have
an
a
option.
clarification on that.
That's an option for sure.
Okay.
Good luck.
Okay. Thank you.
You're welcome.
I really appreciate it.
My pleasure.
Thank you.
Okay, so the last question is also from Ohio. I'm popular in Ohio today. Ohio, go ahead, please.
Hi, Rajiv, sir. Can you hear me?
I can hear you, sir. Yes.
I have certain questions related to my wife's status.
Go ahead.
She is right now on F1 visa, OPT extension, and her EAD expires in September 2024.
All right.
And I have an I-140 approved last year. Now, I was looking for some suggestions. What would be the right time to change her status to H4 EAD, as she is more skeptical about take jobs, layoff, and like I am in a mechanical engineering job, so she was more skeptical where if I loses my job, she also loses her work status.
Okay, so
but if eventually you have to go to that line, what do you suggest?
I think what she should do is she should keep applying for her own H1 also. Okay, but in the meantime, the best thing to do is to bundle your H1, H4 and H4 EAD at the same time. So whenever you are ready to do either an amendment, extension, transfer of an H1B, bundle her H1B and EAD and premium everything. You will get everything within a matter of weeks.
So my H1 is already, like the extension is already done. How do I bundle it for?
Well, talk to your lawyers. Talk to your lawyers. They should be able to refile with certain changes. That's never an issue. There's a way to do that. And they can bundle the H4 and H4 EAD with that. Now, an employer may not want to spend the money again because technically the H1Bs should be paid by the employer, right? So they may not be willing to do it.
Right.
But that's between you and your employer and your lawyers. It's certainly possible. And it's certainly possible next time there's a major change in your job or there is a change in location. If you do an amendment, you can add her on to the premium processing package.
So right now I am actually working in Michigan but living in Ohio. And for the time being, I'm staying in hotel. We are looking for a place once she get a job here, and then we can look for a better place. So once I have an address,
you can do an amendment, do an H1B amendment, and bundle everything together.
Oh, okay, perfect. That is there. And on the other side, she was also looking for L1 option at her employer's side because the employer has international presence and they're not actually filing H1s, but they do offer green cards.
Is she a senior? Is she a senior?
Finally get into
hang on.
Is it EB1C down the line?
Is she a senior level person? What does she do?
She is a financial analyst.
Yeah, that's not a executive or managerial level position.
Right, not at this moment, but she can do that. I mean,
well,
she
if they
has done that before.
If they transfer her, for example, to Mexico, and she's a financial manager or a VP of finance, definitely she would be entitled to an EB1C as long as her job matches the criteria. And we have done that for many people where there was a deliberate attempt to capture EB1C by going abroad for 1 year, and it works fine. No problem.
Okay. And by that time, till that time, she can be on any visa. I mean,
she has to be outside the United
F1
States.
Or H4.
She has to be outside the US. But once that 1 year is over, she can come back on an L1 and start an EB1C, or she can just do an EB1C staying outside the US. Many choices.
Okay, and she can do that EB1C change while being on H4 EAD as well.
Absolutely, she can.
Perfect. Thank you, Mr. Rajiv.
You're welcome. Good luck. Okay, ladies and gentlemen, as always, it's a great pleasure to hang out with you. I'll see you again in 2 weeks. Be well, everyone. Bye-bye.